What does the Supreme Court's Chevron deference decision mean for my business? Oh, hi. I didn't see you there. Welcome. I'm glad I wore my microphone. So, this is one that I've been meaning to do for a while because I see a lot of super zoomed in analyses that say way too much about too little, and a lot of super high level analyses that say too little about too much. So, I'm going to try to hit the sweet spot here as best I can. If you know me, you know that I like frameworks that are useful, meaning that they've demonstrated the power to explain the past, explain the present, and predict the future. Now, the framework that's the most useful for understanding what's happening here is called the iron triangle. And lots of people use this in lots of different iterations, but it originated from the political science literature from researchers like David Truman and Theodore Lowy in like the 50s and 60s, and it's evolved since then. And it goes like this. I'm going to put the triangle up. I'm going to try to flip it in my head. I figure if my wife can teach aerobics backwards, I can do a backwards triangle. Maybe. Let's find out. So, at the 3 points of the triangle, you got bing, bang, bong. You've got legislators and the executive branch. You've got regulators, and then you've got private interests, which can include individuals. It can include groups like corporations, advocacy groups, professional associations, and so on. So each point on the triangle has a different set of levers that they can pull to influence the rules of the game for your business. Now, here that influence is represented by these arrows. Now, here's the way that we typically think about these influence pathways. You've got private interests who petition the government through voting, lobbying, interest group pressure to write laws and issue executive orders. And then these, the influence here is the accountability that you provide every few years with elections. The dollars that fund these elections, putting money towards projects that make legislators and executives look good with their constituents, those sorts of influence levers. So legislators and executives write the rules, they pass them to regulators for on-the-ground enforcement. Now, the influence here is through congressional oversight, also agency funding decisions, new agency appointments, and rhetorical bullying from an executive. Now, regulators enforce these laws on private citizens. Their influence is being able to reward or punish compliance and non-compliance with regulations. They do this with permits, they do this with fines, recalls, consent decrees, strongly worded warning letters, and private firms work within these rules to trade goods and services with one another for money. Now, if this sounds familiar, it's because these are the general mechanisms of influence that we learn about in high school civics, and from every after-school special about the subject. And there are other mechanisms of influence that fall outside of this counterclockwise motion and start to move a bit clockwise. So regulators, they have a lot of leeway in interpreting laws that are handed to them, using their expert knowledge to make these day-to-day regulatory decisions without going back to the legislators to ask. Now, these can be shaped by private interests through public comment on proposed regulation, shaped through collaboration with private firms to develop new regulatory pathways. The revolving door of experts moving between regulatory positions and private firms, the direct funding of regulatory agencies by industry, like we see with the FDA's prescription drug users fee program, and so on. So regulators also have soft influence on legislators and executives because a lot of their tenures span across several administrations, and they could drag their feet on proposed changes while they wait for a more palatable executive or legislative body. They also have social media. They can actively resist, for a little while on their social media accounts. All right, and on the last side, you've got legislators and executives who are able to drive popular opinion through rhetoric and also through compelling private commerce, which is what we see when when there's a mandate for everyone to have health insurance or flood insurance from government approved providers. Now, there's also some really interesting beyond market dynamics between firms and private citizens, which we call private political action rather than public politics. And there's some really cool stuff here, but I think that's another story and another triangle to be told another time. Now, to the Supreme Court's Chevron deference decision, which overturned an earlier ruling which was in favor of Chevron and against the environmental group, the Natural Resources Defense Council. Now, at the root of the original decision was the issue of what are courts supposed to do when the language of the law is ambiguous. Now, in this case, NRDC and Chevron were arguing about what legislators meant by a stationary source of pollution, because adding a new source of pollution requires new permits, which can really hold up energy project development, which is not great for Chevron. So they wanted to be able to modify and expand their existing facilities without new permits, because the whole energy facility would count as a single source, as long as it didn't increase the net emissions from that facility. So they wanted the EPA to have the ability to apply their expert knowledge in the space to interpret this ambiguous language in Chevron's favor, rather than the court trying to sort it out the language itself or kicking it back to legislators to deliberate on, which is, it takes forever. So the courts were instructed to defer to the expertise of the regulators, as long as the interpretation was reasonable. As I'm sure you've noticed, that's another very vague term, which makes the whole thing sort of an irony triangle as well. So back to the triangle. By undoing the deference from courts towards regulatory expertise, the Supreme Court is trying to reverse these clockwise influence pathways and restore the counterclockwise influence pathway that we all learned about in civics class. Now, this connects to a much larger movement by populist and libertarian types some libertarian types who want to reduce the influence of the private sector interests on the public sector. Now, theoretically, the decision reduces the number of access points for direct regulatory capture by industry, meaning that the regulators start serving the companies that they regulate more than their voting constituents. The COVID experience accelerated this issue by casting popular light on some things like the Prescription Drug Users Fee Act, where industry was funding the FDA, and the perceived moral hazard that comes when the government shields private firms against liability. But there's also several other prominent people on both sides of the aisle that have echoed this with slightly different messaging. You've got Bernie Sanders, who led the charge really early against the relationship between the FTC and the finance sector. You got folks like Professor Ivana Kadic, who shine a light on the incentives created by the revolving door between government and industry. You got folks like Rand Paul, who stoke concerns about unelected lifetime bureaucrats who are making public health decisions that might supersede democratic norms. And then you got Mr. Donald Trump and his now infamous drain the swamp rhetoric, which I believe has evolved into demolish the deep state or something like that. With a likely future, a possible future of the president being able to appoint regulatory officials, from the top down. So this new ruling essentially shifts concerns about capture from unelected regulators to elected legislators and executives who are theoretically tied more closely to the will of the people because they were elected democratically. Now, practically, what does this mean for my business? Well, it's going to be bananas for a little while, but there's things that you can do, and there's some things that we can say based on the size of your business and the space that you're playing in. So, for example, if you've got a novel or a disruptive product or service that falls outside of existing regulatory frameworks, this ruling makes it more difficult to just go in and find the right person in an agency and work with them to forge, new or special regulatory pathways. So even before the full implications of this ruling are realized, Regulators are people, and people follow incentives. So regulatory personnel are going to be very concerned about their jobs, and they're going to want to avoid rocking the boat until this gets sorted out. And this becomes especially true if Donald Trump takes office in January. So more broadly, the decision is weakening the influence of regulators on private interests and regulators on legislators, and it's strengthening the influence of legislators on regulators and private interests on legislators. And this can make direct collaboration with government agencies slower and more difficult for small firms who might not have a fat war chest for lobbying to help them set legislative priorities. And priorities are going to be very, very important, because if legislators are expected to codify everything into law exactly as it's to be enforced, it's going to create a bottleneck. So the ability to prioritize where legislators direct their attention becomes even more important. So while everybody is likely to retain the ability to participate in regulatory public comment, the mandate for public-private partnership is going to need to be clearly codified in related legislation. Now, if you're a smaller, more agile firm in a new space without a lot of firm regulations, this is probably going to be great for you, because you can act quickly, you can set best practices through self-regulation while the product or your service gains popularity, and legislators and regulators catch up. That's how Uber did it. That's how the whole internet did it. It's also good for big industry lobbyists in really well-defined space, because they can more directly influence regulation through legislation. It's not so good if you're a smaller competitor in an already defined space, because you're going to be competing more directly with these big lobbyist dollars. But if you're a smaller firm in an already defined space, you do still have some legislative influence channels. Two strategic pathways here. So first, you can build coalitions with big lobbyists with whom you share common cause. And you can piggyback on these relationships that have been forged with other coalition members. You can also assemble coalition members from other private interests, like advocacy groups, which are able to put pressure on legislators to act. So what's the takeaway here? The takeaway is that there are always things that you can do to influence the rules of the game. Those things are just changing, and they may change very rapidly in the next 6 months. Thanks for listening. This is Eric Smith from Tangible IQ signing off.